given. Witness credibility.
No objection.
Defendant testifying is out, would not be given, but defendant not testifying would be given, correct? Any objection to the instruction, defendant not testifying?
No objection.
Okay. Presumption of innocence, this is a duplicate. This is the closing one. It will be given, it's just a duplicate. This is the closing reasonable doubt instruction. I'm not going to give that in favor of the more complete initial instruction. Inferring the required mental state, any objection?
No objection.
Motive,
No objection.
I believe this is a duplicate from the defense as well. Do not consider punishment.
No objection.
The offense requires conduct and mental state, any objection?
Yes, Your Honor, on this instruction, we do have an objection in relation to the language in regards to failure to act. I don't believe that there's any evidentiary basis in this case to instruct the jury based upon a failure to act when the law requires a person to act. And so I think that aspect of the instruction should be stricken.
Let me... What's the state's position on that?
It's a model instruction, Your Honor. We'd prefer the model instruction be given. I think when they go to the elements, that's what's really going to guide them on what they're going to have to find here.
Is there any basis in the evidence that would indicate a failure to act, the defendant's failure to act when he had a legal duty to do so?
Well, I mean, not really, Your Honor. I mean, if he were to have placed Michele MacNeill in a circumstance and then not acted upon that in getting her out of a dangerous circumstance, yes, but I don't think that really applies here. We're not asking for the court to instruct the jury that there has been a scenario like that here. So,
So your proposal would be to just have it read conduct means an act?
Yes, Your Honor, and then delete to the period and then have it resume and act as a voluntary movement of the body, and it can include speech, I guess.
The court will amend the instruction to read conduct means an act, period, eliminating the words or the failure to act when the law requires a person to act. It will then continue, an act is a voluntary movement of the body, and it can include speech.
we should also strike the parentheses, it says, or failed to act.
Thank you. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, and will strike out the parentheses, or failed to act. Next is mental states defined. Any objection?
No objection.
Fact versus expert witnesses.
No objection.
Be given. Separate consideration of multiple crimes.
No objection.
That will be given. Law enforcement testimony.
No objection.
I think there's a duplicate defense instruction. That gets us to elements. Elements of count one. This is the murder instruction. Any objection to this instruction?
Your Honor, our argument on this instruction would be similar to our argument on the directed verdict motion, which incidentally we renew.
Yes, thank you.
That, my statement there was intended to renew our entire motion for a directed verdict. And then now we we make a similar argument in relation to 3C on the elements instruction. We don't believe that there has been a sufficient evidentiary basis to support giving the depraved indifference language of the elements of murder to the jury. I think that the way that the evidence has come in, either there was an intentional act or there was not. And giving the depraved indifference language in this case would invite the jury to speculate on things such as possibly could it constitute murder if the defendant suggested Michele have plastic surgery, for example, and knowing that there was a grave risk in that. And I don't believe that that's the state's case. I don't believe that they intend to argue that at closing argument, but I do believe that since there is no real evidentiary basis to support depraved indifference, that a jury could read this language and speculate on things that are not proper for them to be speculating on. And so we submit that should not be given.
I would respectfully disagree and rely on my previous argument, and just add that with respect to speculation, juries are instructed to not speculate. And I think it would be unfair for us to assume that they would on that issue. I'll submit it, Your Honor.
At this juncture, the instruction as drafted by the state will be given. I'll hear your arguments. I do want you to, in a more formal way, renew your motion for directed verdict and hear arguments on that. If the instruction needs to be amended, I'll return to it. This is the Russell instruction is next. Do you have an objection to the Russell instruction?
For the record, we would object, Your Honor. I have read the Russell case, and I believe that this instruction is consistent with the language of that.
I would just add, Your Honor, we felt, I think that this should apply actually to both count 1 and to count 2. We've only included this one instruction as it would apply to the murder, but there are other prongs under obstruction of justice. It's the same reasoning.
Any cases that address that?
As it applies specifically to obstruction of justice?
Yeah.
I don't believe so.
I think, as I understand the Russell reasoning, the idea was that statutorily we have now more specifically defined the common law idea of malice aforethought. And the reason that we can, there's this narrow, and I think Russell says it's a narrow exception to the jury unanimity rule, is that that's what we've done. We could just instruct on a malice aforethought at common law. I don't think that that's true of other statutory crimes, and given Russell's indication that this is a narrow exception to that jury unanimity thought, my intent would not be to instruct in a similar fashion for obstruction of justice. Depraved indifference, any objection beyond what you've stated?
Not beyond what was stated.
That will be given absent a different determination after hearing the defense's renewed motion for directed verdict. Serious bodily injury instruction, definition.
No objection.
The elements instruction count 2 for obstruction of justice. Any objection to this instruction?
Your Honor, on this instruction, we would object to subsection 3A being given to the jury. I don't believe that there is an evidentiary basis for that aspect of the obstruction statute to be given. And then 3D, I believe, is confusing. And also we'd request that section be stricken or modified. It says, provide false information regarding a suspect or witness, the conduct constituting an offense, or any other material aspect of the investigation. Who's it referring to is the question. So, for example, Alexis MacNeill testified that, that Mr. MacNeill said that the police may have taken the drugs. And so the way this instruction is written, a jury could infer that, well, that was false information and therefore he's guilty of instruction. Which also goes along with the argument in relation to direct verdict in relation to the statute, that the plain language of the statute is implying that there's an investigation underway and that the false information would have to be in relation to an ongoing investigation.
Yeah, providing false information to a co-conspirator, for example. Who do you have to provide it to? Is your point? Yeah. Okay. What do you propose that it be amended to read? That D be stricken?
That's our proposal, that it be stricken.
I'm thinking of the medical examiner providing false information, for example, to the medical examiner regarding any other material aspect of the investigation.
And I would think that would fall under C as well. But if it doesn't, if C isn't adequate to address that scenario, which I understand Your Honor's point, but the medical examiner, again, I don't believe should be considered under here, because I don't believe that the medical examiner is an investigation for purposes of where obstruction of justice can occur.
Okay.
We recently did an appeal, and it's a little different, but somewhat analogous. It's on a case where a defendant was accused of threatening a zoning officer, and that verbal threat was charged as witness tampering. However, there's a separate statute that deals with threatening a public official. And we won a summary reversal on appeal because of the ambiguities in the statute and to what it applies. And I think that a similar argument can be made.
Was it because two statutes prohibited the same conduct? Is that?
It wasn't a Shondell motion, no.
Okay.
It was because there was a statute that addressed interfering with a public official.
Okay.
And that a public official was not inherently a witness, where the witness tampering statute would be applicable. And here, I guess that maybe it's a little bit of a stretch, but my point is that the medical examiners are not law enforcement. Just like a zoning officer is not inherently a witness. And so in my other case, if you threaten a zoning officer and you violate the law that says you cannot threaten a public official, well, then you've created a witness from that point. But they weren't a witness per se at the time of the threat. Yeah. Here, the medical examiner is not a law enforcement position. It's not the type of investigation that this obstruction of justice statute is referring to. And so to include an instruction or an element of the statute that is applicable to a medical examiner investigation, I think would be error. That's kind of convoluted. Did I make my point?
No, I think I understand. What's the state's position on this?
First off, Your Honor,
I'm just looking at the words in paragraph 3, investigation, apprehension, prosecution, conviction, punishment. All of those suggest a criminal justice context rather than an administrative context.
Well, the medical examiner's office, if you recall, Dr. Gray testified that he's actually charged by statute to investigate the death of an individual that's referred to his office to determine a cause and manner of death.
That's an administrative determination, right? I mean, he's not the medical examiner is a arm of the executive branch. I mean, the Division of Water Quality has investigatory responsibilities as well.
Yeah, I just think that the medical examiner's close relationship to law enforcement, I mean, they work together. He's almost an arm of law enforcement in homicide investigations. It's relied on all homicides.
Well, and you
where
have
there's
the
a-
assistant
where there's a
medical
body.
examiners in various sheriff's offices
We do, such
around
as-
the state.
Such as Spencer Cannon here, who can do much of the same thing as a law enforcement officer would do. Protocols are different. They, of course, rely on law enforcement as well. But I think it absolutely applies here because, I mean, number one, it doesn't say law enforcement.
Yeah,
And
it doesn't, well,
prevent the
and that's the problem, is it doesn't say anybody, but there, I think everybody would agree, you know, there's got to be you have to provide false information to somebody who matters to the investigation. What should this read? To provide false information to investigatory authorities? I can't imagine that the legislature would included a co-defendant, you know?
No, I would agree, Your Honor.
Yeah.
I think you're accurate, but I think here, like, for example, with the medical examiner's office, they're undoubtedly doing an investigation into the individual's death. They're collecting toxicology, blood samples, sending that to the state lab with the idea of looking at the circumstances of this individual's death. One of the things they're considering is homicide.
Yeah.
Homicide is a criminal act.
Well, and one way to impede a murder investigation is to secure from the medical examiner an opinion of natural causes or undetermined, so,
Exactly, or accident.
okay, I understand.
With respect, Your Honor, to subsection A of 3A, prevent by force, intimidation, or deception. You know, there were statements by the defendant to law enforcement as they arrived at the house about her having slipped and fallen. A number of attempts, the state believes, to deflect suspicion away from him to make this look like an accident.
Would you have any objection to eliminating force and intimidation? I don't think there's
No, I think that'd be fine.
any evidence of that, so it would read prevent by deception.
Yes, I think that's fine.
And then down at D, I agree with the defense that we ought to, in my view, to resolve the medical examiner issue, I think the unique role of a medical examiner in the context of unattended deaths in rendering an opinion about cause of death, including homicide as a potential determination, I think that providing false information to a medical examiner in this context would violate the statute. But I think we need to say here, provide false information to whom?
Investigative authorities. With that, Your Honor, we're probably going to, if we do make that amendment, we may need to define investigative authorities.
We do, and I would define that to include a law enforcement officer or representative of the medical examiner's office. Can we eliminate provide false information to investigative authorities regarding a suspect? That didn't happen here, right?
What? Couldn't he be the suspect himself?
He could, but did he provide false information regarding himself? This is, I think, generally,
Identity?
I was thinking in terms of someone harboring, you know,
Well, I was thinking in terms of, I didn't want her to have the surgery.
okay, I see. What about a witness? Any false information to investigative authorities regarding a witness in the case? Gypsy Willis is I don't know.
I don't think we have evidence.
It's hard to, yeah. So I'm just trying to, there is evidence of false information being provided regarding conduct constituting the offense.
Maybe, Your Honor, one way I was thinking about this was today, Jimmy Van Zant testified that the defendant told him Dr. Von Welch said that he had cleared her to go forward with the surgery. And if something similar had been said to an investigative body, that would be false information about a witness. I'm trying to think if there was a similar one made to law enforcement.
I like the or language, Your Honor. I think it cures it. It's this, or that. It's the way
Okay.
the statute reads.
It does. I'm going to instruct as to paragraph D with the addition of two investigative authorities. The or allows the jury to assess any one of those. And the defense's objections to the instruction. Any others you want to state for the record?
No, Your Honor. Well, yes, could I just make one more objection on the record? I think that for the reasons that we've argued, that the obstruction of justice statute is void for vagueness as applied to the facts of this case in relation to who constitutes an investigator or to whom a statement must be made, and whether the investigation has to be existing or contemplated.
Thank you. Do you wish to be heard?
I would just say, if that is the case, we would just ask the court to strike the two investigative authorities and let it read as though the statute reads, which contemplates an investigation.
In my view, adding the language cures the issue because it instructs the jury that false information needs to be provided to people who have the capacity to affect the investigation itself. That's clearly what obstruction of justice is, and as applied in the case, a person who, viewing the facts in the light most favorable to the state, if the defendant committed a homicide, having committed that crime, he is on notice or aware that an investigation, that his own investigation, apprehension, prosecution, conviction, or punishment is possible, and actions taken by him to hinder, delay, or prevent any of those constitutes obstruction of justice, even when those activities occur before investigative authorities are aware of the act. In fact, that's when obstruction of justice can be most effective. And so, as applied to the case, I don't think that the statute is void for vagueness, especially with the addition of investigative authorities, which cures the problem. The case I'm thinking of on that issue is the DeHart. It's either DeHart or DeHaan. This is the co-defendant of Pinder, and she was charged with obstruction of justice, and knew that Pinder had committed homicides, then went to Idaho, but it's unclear in the case whether they even knew that authorities were aware that the bodies had been disposed of on the Pinder Ranch. They go to Idaho, but she knows that he's committed these homicides and engages in activities to hide him. She makes calls to determine whether or not law enforcement have made contact with family members. And so it seems to me in that case that the activities are ahead of law enforcement. and she's convicted in that case of obstruction. The next one is you are instructed that the criminal offense of murder is a first-degree felony. Why are we doing that?
I did that only because the last requirement to prove obstruction of justice, Your Honor, is number 4, the last one.
Yeah. I think we have to do that.
It does take it out from being capital, and I'm aware of a number of cases where juries have been instructed that they're not hearing a capital case.
Can we just say the conduct which constituted a criminal offense would be a first-degree felony, and just, do you have any objection to that? This is back on the elements instruction number 4. I can either eliminate capital felony, or we could add to the next instruction. This is not the defendant is not charged with a capital offense. However, murder is a first-degree felony.
Issue, Your Honor, is a number of people talk to me and they assume every murder case is a capital case.
They do. Yep.
So eliminating that might be the simplest.
Do you have a preference?
I think if we eliminate capital felony on the obstruction, that would be the simplest way to.
Okay, what I'll do is it will read the conduct which constituted a criminal offense would be a first-degree felony. And then the next instruction says you are instructed that the criminal offense of murder is a first-degree felony. And we have the instruction that says don't consider punishment, so that will take care of that. Do we need the date of an offense not required? Do we need this instruction?
Only the communication with the medical examiner's office was the next day, April 12th.
And obstruction occurred maybe in varying times. Do you have any objection to this?
No, Your Honor.
I'll give that one. Next is jury deliberations. Any objection? Four-person selection and duties. Any objection from the defense?
No objection.
And this instruction is about questions. I think I would like to say these instructions, we can have it this way. Should you in your deliberations have questions regarding any instruction or other issue, please reduce the question to writing, have it signed by the foreperson, and submit it to the bailiff. However, these instructions should contain all the information that you need.
I would
Almost seems like an invitation.
That's my concern. Any objection to that? Because usually when questions come out, we're always referring back to instructions anyway. What I'll put is, however, these instructions should contain all the information that you need. Or all the information
Required to deliberate?
Yeah, you need to deliberate. Is that all right? Thank you. Any objection to the verdict form?
No, Your Honor.
Okay. Let's turn to the defendant's instructions. In custody informant, any objection to this instruction?
No, Your Honor, I believe it's a Muji instruction.
It is.
I'm assuming the law would be taken out of that.
Yeah, I'll eliminate the, in fact, do you have these electronically? Maybe you could email them to Callie, and do you have yours electronically here?
Yes.
Just email them to Callie, that way I can change them. Next is neither possibilities nor probabilities can substitute for certainty beyond a reasonable doubt.
Your Honor, we believe that the proof beyond reasonable doubt instruction is sufficient, that it covers this. There's been discussion of probabilities and possibilities among some of our expert witnesses, which support their standards they're looking at as far as reasonable medical certainties. I think this is confusing. And I think the case law supports using proof beyond reasonable doubt instructions to cover these types of things, to simplify it.
Do you wish to be heard?
Yes, Your Honor, we have two instructions that are intended to address the circumstantial evidence issues in this case. There's this one, and then 3 instructions later, there's an instruction that probative inferences from circumstantial evidence must be more than speculation and conjecture. Both instructions, I believe, are supported by cases in the state of Utah, and I think that they're applicable to this case because the vast majority of the evidence in this case is circumstantial, and I think that it's, in this case, more so than most, it's important for the jury to understand the appropriate way to evaluate circumstantial evidence. And so I think that these instructions are good law and ought to be given in this case.
How do you address the issue of experts talking about what was probable and not? I think I've heard, both from the defense today, the expert talking about what was probable for a man of 51 years, 6'2", to lift.
I think that that's addressed in the expert instruction, isn't it, where it talks about
What weight to give to opinions?
I think that the expert instruction is fairly clear in telling the jury how to evaluate their opinions, and that would mitigate any potential concern from these circumstantial evidence instructions.
I'm going to grant the state's motion or objection to this instruction. I do find it to have merit. Experts have talked in terms of probabilities. My concern is that the language conflicts with the reasonable doubt instruction that talks about absolute certainty. And will only create confusion about the standard of proof, which is a critical matter to the case. So that instruction will not be given. Law enforcement, this is a duplicate. correct?
Yes.
That will be given. The next instruction, I wasn't clear on how you wanted this to be. I think it suggests that we would have a list of 404B acts that you specifically wanted instructions about and their limited purpose. So how would you want this to read?
That the defendant engaged in an affair before and after the passing of Michele MacNeill.
Okay. Can I just put engaged in an extramarital affair? Marital affair before the acts charged in this case? This evidence for the limited purpose of motive?
I think intent is in play as well.
I don't believe so, Your Honor. Our defense, as we've argued in the past, has always been whether the act occurred or not whether Mr. MacNeill did an act but lacked intent for it, and I think that Your Honor's ruling in allowing it was focused on motive too. So I think motive is the appropriate term.
Wish to be heard on that?
I'll submit it, Your Honor.
I think the defense is right. It will read motive. Noting the state's proposal, which I've denied, any objection from the state?
No.
Okay, I will give that instruction as amended. The next, the probative inferences from circumstantial evidence must be more than speculation and conjecture. Any objection from the state?
Your Honor, I think the circumstantial evidence, the evidence instruction that talks about both direct and circumstantial evidence should suffice. And I believe we're otherwise instructing the jury that they're not to speculate when
Okay.
reaching a conclusion.
Thank you. From the defense?
I think that the circumstantial evidence instruction defines what circumstantial evidence is in relation to the definition, or not the definition, the explanation of if you step outside and see the ground is wet and people are putting away their umbrellas, then you can feel the rain. But I think that this instruction goes beyond that. And I think that it is consistent with the crystal ball decision, and we'd ask that Your Honor give it.
Okay. This is a circumstantial evidence case. I think giving the instruction is appropriate.
Your Honor, can I be heard?
Yes, go ahead.
One of the state's instructions, I'm trying to find out which it is, this is the Muji one, and it says, the law forbids you to be governed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. I think that addresses that.
Yeah, but that's in the context of the, you can't make a decision based on emotion, right? That's in a juror duty instruction, correct?
It's in weighing the evidence together fairly, conscientiously.
Yeah. I think giving emphasis in the context of circumstantial evidence to avoid speculation and conjecture is appropriate in this case. It will be given. Defendant not testifying, we've already talked about, that will be given. Motive, this is a duplicate of the state's, correct?
Yes.
Do not consider punishment as a duplicate of the state. Presumption closing is a duplicate. witness credibility is a duplicate. Do you wish to take any further exception to the instructions from the state,
No. Not
from the defense?
No, Your Honor.
Are there, last night, we talked about the giving of any curative instructions. As you think through trial over the past 4 weeks, do you believe that there's a need to give any curative instructions
I don't, Your Honor.
from the state? Very good. What I will do, counsel, is if you could email the electronic copies of your instructions to Callie, I will make these changes, and depending on how long that takes me, hopefully you could email them back to you so that you'll have an electronic copy yourself tonight. Otherwise, they'll be on council table in the morning. We talked a little bit about closing argument. I think instructing will probably take 45 minutes or so, and the state's looking at maybe longer than an hour.
Maybe a little longer than an hour.
Okay, and from the defense?
I would think a little bit less than an hour.
Okay. So that puts us to the jury before noon then. Counsel, there have been media requests to receive copies of the exhibits in the case. My view of that is they ought not be disclosed until after the verdict has been rendered. We've made arrangements to have copies of the exhibits put on CD. They will be available within 1 business day of a request being made for them. Exhibits that are too large to be put onto CD, arrangements could be made to photograph those through the trial court executive. Would you approach the bench? We'll reconvene at 8:30 in the morning. Court's in recess.